Hi there, welcome to the PSRB LAWCAST. I'm your host, Adam Wright. Each episode features dynamic conversations with attorneys from the law firm of Pellegrini, Seeley, Ryan, and Blakesley in Massachusetts. The goal is to try to bring you some information about the various aspects of personal injury law and the legal process. And we understand that approaching a law firm to help you can often be kind of intimidating, which is why our podcast is designed to make personal injury law easier to understand and to help you navigate the processes with greater comfort. Now, remember, every case is different, and in order for us to provide you with accurate information and advice relevant to your specific circumstance, it's really important to set up an appointment with one of our attorneys to meet in person. Today, we're discussing serious injuries which occur at work, which are covered under something called Section 36. And in addition to all other compensation employees are paid under the Workers' Compensation Act, there's also additional payments for specific injuries as well. And to break down Section 36 for us and to discuss payments for these extreme injuries is PSRB attorney and partner Tom Downey. Tom serves clients in the areas of disability law, workers' compensation, labor law, and Social Security Administration law. He was formerly a claims manager for a municipality with over 7,000 employees, which has given him pretty extensive experience with public employee disability law. Tom holds an MBA with a concentration in healthcare administration from Western New England College and his JD from Western New England College School of Law. Tom's admitted to practice law in the state courts of Massachusetts and before the Social Security Administration and the Massachusetts Department of Industrial Accidents. All easy for me to say. Hey, Tom, how are you?
Good morning, Adam. I'm doing fine, thank you.
Well, it's great to have you here because these are real serious issues that obviously and unfortunately come up, I would think, quite often when we talk about workers' compensation law. What are Section 36 benefits?
Well, they're a single benefit under the workers' comp law, which is state specific. And so under Section 36 of the law, there is a benefit for scarring as well as permanent loss of function and something also called disfigurement. And I think the nature of workers' comp is something that most people don't pay attention to on a day-to-day basis because we're so busy at work and trying to do the work of 2 or 3 people. And oftentimes, workers' comp doesn't come up in conversation. However, when someone gets injured, then there's really an immediate need for a lot of information. And and that's why we like to share as much information as we possibly can, just to make people aware of what their rights are and how the law works.
And this is one of the more serious elements of workers' compensation law because this applies to people who have significant injuries and permanent injuries, correct?
That's true. And if you are applying for benefits for scarring or a permanent loss of function or disfigurement, these are sort of permanent injuries that you sustain. So they, by their very nature, are serious. And there's actually a 6-month waiting period before you can even claim these benefits to allow for proper healing and to restore loss of function and to be declared at a medical end result. So they really are serious. They're only evaluated when someone's completed all of their medical treatment. So they certainly are serious.
Now, what kind of injuries are we talking about specifically?
Well, it's important to note that the law was changed in 1991. So when it comes to scarring, now it's been limited. Previously, there was a benefit for scarring anywhere on the body. And then with the change in December of 1991, the scarring was limited to the face, neck, or hands. So it really...
Places that are visible.
Exactly. Yeah. Under the theory that employee that has a visible scar might have greater difficulty finding new employment and thereby may have incurred further impaired earning capacity as a result of the work injury. And so that change it was significant to people. And what we find as workers' comp attorneys is that someone who has a scar is much more cognizant of the fact that they have a scar than someone they may be talking to or working with, so it does leave a permanent mark on someone, and that they are keenly aware of.
Yeah, and I know that it's scarring as well as disfigurement. What's the difference between the two?
Yeah, that's a good question. And disfigurement really is really been interpreted. If someone ends up with a limp, then a permanent limp, and again, it has to, the normal recovery period has to take place, and recovery therapies such as physical therapy, they have to take place and again be declared at a medical end result. But an example of disfigurement might be someone who has a limp at the end of all their treatment, or has to use a cane on a permanent basis that is prescribed by their medical treatment provider. In most cases, we're really talking about orthopedic surgeons, that there's been an injury to a major body part, but there can be other cases where we're dealing with, lacerations as well.
And the third would be obviously loss of function. So I'm thinking like if somebody loses an eye, or maybe they have a permanent injury to their limb that no longer works. I mean, would that be considered part of loss of function?
It would. That's exactly correct. And what we often see, I would say as a general rule, bearing in mind that there are exceptions to every rule, but if someone has had surgery, there's more than there's probably an 80 to 90% chance that they are going to have a measurable loss of function. And these loss of functions can only be done by doctors, and they have to be done in accordance with the AMA guidelines. So they're fairly, strict in how they're the requirements to qualify for this benefit. And however, again, one has to complete all of their medical treatment. But again, if they have a permanent loss of function, it is, going to be with them, forever. So it certainly isn't a benefit that they really should be addressing to compensate them for that loss.
And this would be in addition to any other workers' compensation benefits that are being paid.
That's correct. What we're talking about today is scarring, loss of function, and disfigurement. This would be in addition to weekly benefits, and it should not be misconstrued as a settlement of any kind. It's not a settlement. It's just a payment for a scar or a permanent loss of function rating or some type of disfigurement.
You talked about how the determination of these injuries is decided by a doctor. Does the doctor look at the injury, the function or lack thereof? What types of things is the doctor looking for? And the other question I would have, Tom, is psychological impact of these injuries. Is that factored in as well?
Yeah, well, yeah, that's a good question. And I think if I can, before I address that, I think we should just point out, to our listeners that the most important thing that someone should do when they've been injured at work is to file an accident report. And of course, you and I were having a conversation, and, if someone works as a carpenter or a plumber or they're a machine operator, they may say, if I have to file an accident report every time I bump my knee or have a small cut on my hand or something, I'll be doing one of those per day. But I think the takeaway is that, if you've got something that it lasts throughout the rest of the workday, you should report it and give a copy of that accident report to a supervisor. Make sure they're aware of it, and keep a copy for yourself. This is what we call notice to the employer, and that really just records what's happened. So at a later date that the employee is not on the defensive about not having.
There's a record of it.
Exactly. And let the employer know and get the proper immediate medical treatment that's required. And really that starts there. But to answer the question you just mentioned about the doctors, their role and what are they looking for? Well, there are regulations. In addition to the law, there are regulations like a companion set of rules that we use under the workers' comp law. And those regulations for loss of function, for example, require the doctor to declare that someone is at a maximum medical improvement, what we call an MMI, and the doctor then would provide a degree of loss of function. So, for example, let's say someone has shoulder surgery for a rotator cuff tear, and then what we ordinarily see is the surgery and then a period of recuperation, which includes physical therapy. And once they're declared at the end of their medical treatment and recovery, no sooner than 6 months from the date of surgery, then we often write to that surgeon and ask that doctor to provide the degree of permanent loss of function in that particular shoulder in accordance with the latest guidelines from the American Medical Association, the AMA, which I think it's the 6th edition right now. So we also have to identify the permanent monetary loss that we're seeking. There is a schedule of loss of functions percentages, which are based upon the state average weekly wage. And so we put that in the claim. But and if we're talking about scarring, ordinarily what we see is the doctor will put in the report the length, the width, and the degree of discoloration of the scar in a report, and we oftentimes include a photograph of that scar when we file the claim. As far as the psychological impact, the workers' comp law, I often tell people that it can be interpreted sort of as a somewhat callous law, that it doesn't have provisions for pain or suffering benefits or loss of consortium. So it should not be misconstrued as being similar to the personal injury law in Massachusetts. It's not. And the psychological component is hard for an orthopedic doctor to measure, certainly. And what we see them do is refer people out to another specialist, such as a psychiatrist or a psychologist, if the work injury has really caused a psychological injury too, and that can happen. And what we encourage people to do, again, is to give notice to their doctor and ask for referral to the appropriate specialist. The psychological injury is really not, there is a benefit.
Would that be under like maybe Social Security?
It could lead to someone applying for Social Security if in the opinions of the medical providers that they're unable to continue to work, yet perform what Social Security calls substantial gainful activity. But first, it's so important to get that treatment right away. But there's Section 36, the payments under that. We don't ordinarily see someone being paid for a psychological injury.
What about cognitive function, loss of cognitive function? Would that follow along with psychological, or is that a separate entity in itself?
That's a good question. And there is a payment for like language comprehension, which, most people would say is a cognitive impairment that is permanent. And I will say that those injuries, as compared to the orthopedic type injuries that we see to the shoulder or to the spine or to the knees or the ankles, but a cognitive injury, that it can be paid, a claim for benefits can be filed, but what we see is a doctor has to be able to provide that loss, the cognitive loss, in the form of a percentage, and which is difficult to do, not impossible, but it can be difficult. And usually we see the person either dealing with a clinical psychologist or a neuroclinical psychologist or a neurologist when we talk about cognitive impairment that is in fact permanent.
You had mentioned the law is callous. One of the things that always surprised me is that they actually list particular benefit payments for different injuries, right? So if you lose a finger, it's one amount. If you lose a hand, it's another amount. If you lose the function of your leg, it's another amount. They're all pretty spelled out by the state, right?
They really are. That's true. And I think it can be frustrating. It's a one-time payment. And it can be frustrating to the injured employee because it would just seem to be inadequate. This is going to be a permanent loss for this person moving forward. But, the law is, I guess, what it is. And it really, one of the tough things as an attorney you have to do is tell a client what benefits the law provides and what it does not provide. And we make it a point of telling people sort of the good points of the law and the parts of the law that it just doesn't address these things that are so important. But if it doesn't address it, then we let them know that so they're aware. We don't want anyone to be surprised.
Right. Who makes the determination whether or not these payments will be available and justified for a particular client?
Well, when we represent clients, if it gets to the point where we think a benefit under Section 36 for scarring or loss of function or disfigurement is owed, we would file a claim and then we would appear. Within about 2 or 3 weeks, a conciliation will be scheduled. Most of these claims get resolved at conciliation, even though a conciliator doesn't have the authority to issue a binding order. They give a written recommendation. So, for example, if there's a scar on someone's hand, they will literally measure the scar and they will observe its width as well, measure the width, the length, and the degree of discoloration, and then they will provide to both the employee and the employee's attorney and a representative from the insurer, usually an attorney, this is what my assessment is of the Section 36, the scarring. If it's a loss of function, they don't comment on that because they're not qualified to. What we often see is the insurer will have, if they don't agree to pay the loss of function rating right when the claim is filed, they have the right to schedule the employee for an independent medical exam, an IME with a doctor of their choosing, and the person must attend in order for us to move forward with the claim if we want to appear in front of a judge. I would say more than 90% of cases are resolved at the conciliation level because the law, as you say, is spelled out in plain terms. And even for such things as, I can refer just to the losses of function. It's for the spine, including the cervical, lumbar, and thoracic, but losses for equilibrium, for loss of lung, there's a payment, kidney, language comprehension, sexual function, taste, loss of taste or smell, loss of one's spleen, urinary or bowel loss, and the loss of teeth actually are all clearly spelled out in the law. And so those are things that, a person would be eligible for a payment for. I should point out that when we talk about scars, there is a maximum established in the law. So scarring and disfigurement, the maximum benefit, it's capped at $15,000 per injury. So someone will not be able to get paid more than $15,000 for.
That's just for scarring.
That's right, scarring and disfigurement as a result of one date of injury.
Right. That doesn't apply necessarily to loss of function.
It does not apply to loss of function. And again, that would be rated by the doctor. Often it's the treating surgeon is who we write to. We think that's the most knowledgeable person, of course. So we write to them and most are willing to give a report. And that, again, is a benefit that is so important. I think the benefits we're talking today, because the workers' comp law doesn't have any benefits for the pain and suffering that we talked about before, it elevates the importance of these benefits to make sure that the person gets paid and has some sense that they've been compensated for these injuries, and then they can kind of move on with their life with sort of an assurance or peace of mind that they were treated properly under the workers' comp law.
You mentioned that none of this can be filed until 6 months after the final treatment. How long is the process to determine whether or not those benefits are paid generally? I suppose it depends on the insurance company and whether they...
Yeah, and I should point out that it's 6 months from the date of surgery. So if we're talking about surgery, it'll be 6 months from the date of surgery, but also being declared at a medical end result. So if someone continues to treat, we, again, wait to that. So it's 6 months plus the medical end date.
I guess how often do insurance companies challenge a claim?
They unless the rating is pretty significant, we don't have too many cases that cannot be resolved at the conciliation. I think that we have to remind our clients that what we receive from the treating surgeon is that person's rating, and that can be subjective, and then the insurer's evaluation, which we refer to as an IME, that is subjective as well. They try to use objective criteria, but it's one person's opinion. And but oftentimes, there's sort of a common ground that we can find between the two. They're usually not that far apart, especially if it involves surgery of, for example, if it's knee surgery, then generally if you've had one arthroscopic repair, depending upon if it's the cartilage or ligament or both, they usually are not that far apart, the two ratings.
And once this gets adjudicated, whether in conciliation or before a judge, how long before someone receives their payment?
Once an agreement is entered into, then the insurer has 14 days to send the check out to the injured employee. So, generally we hope that they actually receive the check within 14 days, 2 weeks, but technically the law says the check must be mailed within 14 days from the date of approval of any agreement that's paying them benefits of any kind. One of the most important things that we see is that just to file that accident report and just to give the employer notice, but also seek the medical treatment that you need. It usually ends up providing the best outcomes for someone, but it also will put someone on a path that might be the least resistance from the employer when they're aware that something has happened. But, if they have any questions, they could give us a call at our office. We're always happy to talk to people, and there are many occasions where we don't necessarily have to meet with someone. We can speak to them over the phone. We're always happy to share our advice and our experience, and should we need to meet with them, we're always happy to do that, and we're available, throughout the state. And we also understand that there's sometimes that there's an urgency to their situation, that they often wait to call a lawyer, and they can be reluctant to do that, but we're happy to call them and we don't charge them. I think one note I should include is that the fees for litigation are paid by the insurance company. They're not paid by the employee to us, so they don't have to worry.
Not going to cost them anything out of pocket to pay for an attorney.
That's right. And if they call us and ask us questions, we don't start a meter or look at our watch. We don't do that. That's not how workers' comp works. And that, is a benefit we hope that the employee sees. And so they won't hesitate to give us a call when they have questions.
Before we wrap up, one of the things you mentioned is someone who works maybe in the trades and gets a nick or a cut on a regular basis and doesn't think anything of it, or maybe they twist their ankle or something like that. But those can lead to serious injuries if not treated. And if you have what you believe to be something that's minor, you still want to document it because it could lead to an infection. It could lead to some other kind of issues. It's important to document everything, isn't it?
It really is. And even if, if the person wanted to use, whether it's the end of the day rule, if something is still bothering you, or even a 24-hour rule, that if it's still bothering you, then chances are, it would be better to just file an accident report and just have that. And again, kind of be your own record keeper. Keep a copy for yourself. And, or in a case where we have many instances where someone is paid benefits for a short amount of time, for 2 or 3 weeks, they go back to work. But if they then later go back out and have surgery and they've forgotten, they haven't consulted with an attorney, if they've received benefits, the statute of limitations is told. In other words, it's sort of removed as a limit. So if they had surgery a few years ago and they received benefits, so that means that the insurer is aware of the injury, so they can't say they didn't have notice. So they still would be eligible for a loss of function payment or scarring benefit. Again, if it's on the face, neck, or hands, if it happened after December of 1991. So that's, they could give us a call and we could talk them through that scenario as well.
Well, you mentioned if people should feel free to give us a call. That number is 800-785-5399. You can also visit our website at psrblaw.com. Tom Downey, this is really interesting and important information, and thank you so much.
It's been my pleasure, and I think I speak for all the attorneys here that we're always happy to speak to people and inform them of the workers' comp law. It's kind of one of those things that you don't pay attention to, but when you need information, you need it right away. So we're always happy to speak to individuals, or even if there are groups, labor groups that, would like a summary of the law, we're always happy to do that as well.
Terrific. Tom Downey, thank you so much.